What I wanted to do, and the reason I planned this class this way, is I wanted to explore how the Supreme Court's decisions have impacted the government's ability to deal with climate change. I think that climate change is probably the most impactful long-term crisis that we've ever had to face. It's an existential problem. It's a mouthful, but it really is that large. By now, most of us accept the basic scientific idea that, and the conclusions drawn from it. Burning fossil fuels to generate energy has released and is releasing a volume of greenhouse gases into the Earth's atmosphere that the ambient temperature is increasing at an abnormal rate. That's in a nutshell what it is. These warmer temperatures cause massive melting of glacial ice and oceanic ice. It increased the air and water temperatures, all of which impacts weather and climate, sea levels, and all the conditions for life, plant life and animal life. Just about everything. Judicial decisions, especially those by the Supreme Court, have an impact on the government's ability to deal with climate change when the courts are called upon to interpret what the government is doing to see if they comport with the constitutional or statutory requirements. But as with so many things, it all comes down to politics. And I'll explain. Now, let me give you a disclaimer. I am not an environmental historian. My specialty was legal and intellectual and religious history. I didn't know anything about environmental history until I realized I better learn some in a hurry if I was going to make sense of this class, which I've done or tried to. If I make any mistakes, please forgive me. Environmental history is really a fairly new subfield. It began, and when I say relatively new, meaning that it began in the 1960s. I was alive and almost an adult when it began. That's what I consider relatively new. And it reflects Americans' increased awakening to the impact of human activities in the environment. Let me, for an aside, to prepare for this, I had to hit the books. And I highly recommend this one. It's a book called Down to Earth, Nature's Role in American History by a fellow named Ted Steinberg. It was written in about, I think the copyright's 2007, so it's not that old. It's in its second edition. It's a fabulous survey.
There's Ron.
And I highly recommend it. That's part of my show and tell. Like all species, our conduct has an impact on the ecology of where we live. Agricultural practices, population growth, urban and industrial expansion, consumerism, they all had an impact on every region of the country. And if you want a good study of a region, here's my second and last show and tell. The book by William Cronon, C-R-O-N-O-N, it's called Nature's Metropolis, Chicago and the Great West. And what he does in this book is he takes the history of Chicago from its very beginning up to the modern times. His dad was, Cronon's father was a historian at the University of Wisconsin, and they used to take summer vacations. And they would drive the areas around Chicago in the Midwest. And what he does in this book is he explores how the economic and development of Chicago, its growth and what it took to support it, affected the life of everybody within through 500 miles around it, and how what people did 500 miles around it affected what happened in Chicago. It's a great story, and that's the only reason I brought it. People like John Muir, John Wesley Powell and others wrote and spoke about how what we were doing, that there's a focus, there's something that seems to be going away, this idea of the vanishing wilderness. They spoke about how the wilderness was being lost and needed to be preserved and enjoyed. And to give you an example, just from the 1920s until the 1970s, paid membership in the Sierra Club grew from about 500 up to over 77,000. Wow. That just reflects the American interest. In the 1950s, Walt Disney made a bunch of movies about the places that existed, quote, before civilization left its mark upon the land. That was his mantra. And believe it or not, the Audubon Society in 1955 awarded Disney a conservation medal. I thought that was funny. But it wasn't just wilderness. Urban Americans became many aware of the congested places where they lived, helped along by a number of catastrophic events. The 1961 Malibu fire consumed part of Bel Air's, one of Southern California's premier neighborhoods. In 1969, Cleveland's Cuyahoga River experienced spontaneous combustion due to industrial waste for about the third or fourth time. Headlines told Americans about spills, oil spills on the California coast. People in cities across the country complained of smog levels that rendered their air unhealthful and almost unbreathable. And iconic images helped. And here's a few. Slide. There we go. This helped. This moved people to be more aware and understand that humans had an obligation to do something. And humor had an impact as well. How many of you guys know Tom Ware? Tom Ware. You remember his song Pollution? Yeah. There's lots of things you can drink, but stay away from the kitchen sink. The breakfast garbage you throw in the bay, they drink for lunch in San Jose. Rachel Carson's book, Silent Spring, changed the terms of the debate over environmental reform. She brought hard science to the table. It galvanized people to insist on action, on doing something, albeit not without a lot of pushback from the businesses whose bottom lines were at risk. And she began with ecology. She didn't end there, she began there. That ecosystems are both, they're complex and that everything we do affects them. Everything humans do. They're interdependent and they evolve towards a state of order, but when we interfere with them, intricate members, it starts to unravel. And she was writing at the height of the Cold War. And she showed that pesticide use in the way it endangered animal life was really no different than the way the danger of radiation would affect human life. She tied ecological reform to the Cold War prospect, which really made it much more relevant to people, because in the early 1960s, her book came out in 62, that the Cold War was the height of the Cold War. That was, the Cuban Missile Crisis was that October. So you put that in historical context, you can see how effective it was. She argued that humans were not separate from the ecosystems where people lived, but were part of it. And it was really effective. And Americans demanded action. Silent Spring has been called the Uncle Tom's Cabin of the environmental movement. It's that important. It seems like when enough people complain about something, politicians respond. From 1962 to 1999, during the last 40 years of the 20th century, God, it seems we're a quarter of a way into the century. I'm a kid, I lived in the 20th century. What's this 21st century stuff? During the last 40 years of the 20th century, Congress passed 38 different acts that affected that addressed environmental issues. And I want to list some of them because it shows and confirms the power that the environmental movement had on politicians' responses. Politicians do respond when enough people want something. 1963, the Clean Air Act. It was replaced in 1970 and it's been remodified ever since. It's the primary federal air quality law. And since 1970, it's been administered by the Environmental Protection Agency. I'm going to try and stay away from acronyms if I can. There's so many of them, I had to make a little list of myself, so I keep track of them. But EPA is one of them. And I'm not going to say Environmental Protection Agency every time because I can't pronounce it. The Clean Air Act provides the mechanism for the government making what's called an endangerment finding. That's a critical idea, because when there's an endangerment finding, a finding that something presents a danger to human life and welfare, that's what gives the government the legal right to try and regulate it, because you're trying to prevent the harm that it comes from it. So the endangerment findings legally justify setting and enforcing national standards for emissions of hazardous pollutions. 1964 was the Wilderness Act. It made wilderness preservation a national policy. It's not perfect, but by 2014, there were over 105 million acres to be preserved in their natural state. In 1970, the National Environmental Policy Act, the NEPA, it created the EPA. It created the Environmental Protection Act. Under it, all federal agencies are required to evaluate the environmental impact of all agency actions, and release an environmental impact statement for all projects that require federal approval, or which includes any project that receives any federal money from which emissions may contain pollutants. So its brief is humongous. It's over literally everything that happens. The EPA administers the Clean Air Act and the Clean Water Act, among others. The Clean Water Act came out in '72 as well. It's been amended a couple of times since then. And it does for water pollution what the Clean Air Act does for air pollution. In 1972, Congress passes the Marine Mammal Protection Act and the Marine Protection Research and Sanctuaries Act. That's a mouthful. But if you stop and think about it, it's under these laws that in 1988, the Monterey Bay Sanctuary was created, which makes this such a wonderful place to live. In 1974, the Safe Drinking Water Act regulates and protects groundwater. In 1976, the Magnuson-Stevens Fishery Conservation and Management Act. It addressed overfishing, protected marine fisheries in American waters. 1977, the Resource Conservation and Recovery Act requires federal and state regs that deal with disposal of solid hazardous waste. 1980, what's called the Comprehensive Environmental Response, Compensation, and Liability Act. You'll never remember that, but think Superfund. It's the Superfund Act. It's the one that calls for the cleaning up Superfunds. 1992, the Energy Policy and Conservation Act was revised in 2005. It requires states to adopt energy efficiency standards aiming to lessen dependence on imported fuels, promote clean energy sources, and conservation. That's just and by the way, that's only some of them. I could go on for hours just listing all these laws that came out of Congress. Historians credit, believe it or not, Richard Nixon for being among the greenest presidents, notwithstanding his many faults. But then he had a Democratic Congress to work with, both houses. And I'll have more to say about Nixon in a minute. From 1981 to 1992, environmental policy took a back seat. Reagan appointed Ann Gorsuch to head the EPA, and she vowed to implement his new federalism policy to reduce government regulations. She cut the EPA's budget by almost a quarter and hired staff from the industries that the EPA was supposed to. I will in a minute. She's telling me there remain slides, but it's at the end of this in a minute. She hired staff from the industry was supposed to regulate. Now you can hit the slide. She resigned under pressure in 1983 after it was confirmed that she had intentionally withheld $6 million from being released to clean up a Superfund site in Los Angeles. Why did she hold it? Because she wanted to help the Republicans in that year's California election. Well, she bragged about this to somebody at a luncheon, and she was overheard, and it became a brouhaha, and she quit. And her son is still pissed off over the way his mom was treated, and he shares her anti-regulatory views. This explains some of why Neil Gorsuch does the stuff that he does. Most of the legislative programs aimed at energy conservation and managing harmful byproducts charged the EPA with the job to work out the details. And as a result, the EPA has become one of the largest federal administrative agencies under the executive branch. As one might expect from the 1980s on, and that's, for the last 45 years, environmental protection has fared much better in Democratic administrations. That's just a hard truth. Now, from here on, the story can be depressing, both a little depressing or really depressing, depending on your point of view. Trying to address climate change has been a tougher sell. And by the way, from here on in, booing and cheering is certainly welcome. It might help, it will relieve some stress. Even corporations realize that Americans are concerned about where they live, and some corporations even bragged about being environmentalist companies. But it's different when the threat is worldwide and involve other nations as well. And personally, I think maybe too many Americans, and I'm talking culturally, have a sense of entitlement. It's hard for people to put the environment first, especially when it affects their creature comforts. And that's just a reality.
But it does.
It does, of course it does. But, it's also become a core issue in American political divisions, which itself is a shame. One more slide, I think. Yeah, here we go. Yet by now the science is pretty clear. It's accepted by majority of Americans, MAGA stalwarts accepted. These two graphs I found online, and you put them together, and how can you not be convinced that there's a problem? The one on the left is the emission of greenhouse gases. The one on the right is ambient world temperature. And as one goes up, the other's gone up. Don't tell me it's a coincidence. Now, most of us are familiar with Al Gore's work. Can I change the slide?
Yeah. That's it.
About the risk and impact of fossil fuel emissions on climate, and we've all seen an inconvenient truth. The federal government's awareness of this issue goes back, though, to the 1960s. President's Science Advisory Committee issued a report in 1965 about greenhouse gases, but it didn't get any traction. In September 1979, Daniel Patrick Moynihan, who was working in the White House, wrote a memo to John Ehrlichman, Nixon's chief domestic policy advisor, concerning the need to institute a monitoring system to measure the amounts of gas being released in the atmosphere. And this is the memo. And a little show and tell. It's available online if you want it. Just Google Ehrlichman memo about greenhouse gases, and you'll get a link to this. And you can download it and print it. And in it, he says, I think it's a subject that the administration ought to get involved with. It's a natural for NATO. Perhaps the first order of business is to begin a worldwide monitoring system. At present, I believe only the US is doing any serious monitoring, and we only have 1 or 2 stations. And then he goes on to say who they can talk to. And Nixon was really supportive of this because he saw environmental issues as possibly diffusing some of the political opposition to his Vietnam policies. And it was a way of basically reaching out towards an issue that was not necessarily hard right, that Democrats were in favor of, and embracing it for political purposes. And Nixon thought everything in political purposes. He didn't brush his teeth unless he was thinking about how it affected the politics at the time. That's just the way he was. He was a total politician. But on the other hand, he saw the reward, and a lot of those statutes, Nixon was president from March of 1969 till he resigned in 1973. The Clean Air Act, the Clean Water Act, they came out during the Nixon administration. So, this is why he gets it. So I can give you a little timeline on some of the government's actions and inactions regarding climate change. And I'm going to bring these up to close to the present. In 1977, a unanimous Senate resolution repudiated the Kyoto Protocol. Remember the Kyoto Protocol, where it was the first attempt to get a worldwide group to address climate change. And the Senate unanimously said no because it did not mandate any emission reduction targets for developing countries, including India and China. In light of the resolution, Clinton, who was in light of the resolution, the Senate was never requested to vote on it. In 1978, Congress passes the National Climate Program Act that requires the president to establish a program to, quote, assist the nation and the world to understand and respond to natural and man-induced climate processes and their implementation. So now we've got an actual congressional thing. The president, you got to study this stuff. It's really important. In 1999, the Environmental Defense Fund and others formally request the EPA to address the issue. It's called a rulemaking petition, and it's in the National Environmental Policy Act provides for it. And they asked the EPA to regulate greenhouse gases under the Clean Air Act. The EPA did not complete the process before the 2000 election, which, as we know, the Supreme Court gave to Bush Jr. It's G.W. Bush and George Herbert Walker Bush. I just call him Senior and Junior. In 2003, with Junior president, the EPA denies this petition. They claimed that it lacked authority to regulate carbon dioxide because carbon dioxide is not inherently harmful and therefore it's not a pollutant. The EPA is said to address emissions of harmful pollutants from the source where they're being emitted, not to address substances that are, quote, fairly consistent throughout the world, close quote. And they went on to say that even if the EPA had authority, the EPA would choose not to do so as a matter.
Amy bought it the other day.
Now,
It's okay.
what happened is a number of states, mostly the
I'm
red
just eating it up. It's going bad.
Massachusetts, Vermont, and one or two
Really
others,
have that.
sued to challenge, filed a lawsuit to challenge the EPA's decision. And during Bush Jr.'s 2 terms, a number of proposals are introduced in Congress to affect climate change, but none of them die. Most of them die in committee, and nothing gets enacted during his administration. Now, this case that the that the states had filed to compel the EPA to do something reaches the Supreme Court in 2007. Case is called Massachusetts versus the EPA. It's a 5-4 decision. Stevens wrote the opinion with Kennedy, Souter, Ginsburg, and Breyer along with him. Roberts, Scalia dissented with Thomas and Alito. The 5-4 majority held that greenhouse gases might be pollutants if they are harmful to the people's health or welfare. And policy differences, nor any claim that the science is inconclusive, allow the EPA to decline to address the issue of harm. The EPA said, we don't have to ask if these gases are harmful because that's not our brief. And the court said, oh, yes, you do. You have to assess whether greenhouse gases are harmful to human health or welfare. And that was the decision they made. Interestingly enough, the dissenters didn't contest that part of the opinion. They contested whether the plaintiffs had standing. Because when it comes to greenhouse gases, the dissent said, first off, how can the state prove that it suffers an injury from greenhouse gases? How is the state injured? And the second thing is, even if the state is injured, what can the court do about it? The court cannot clean up the climate. So it's called an issue of redress. So that's what the court decides. The majority says you better look at it. And what happens in 2008? We have another presidential election. And in 2009, President Obama, and now we can cheer, by the way, and his new EPA head is Lisa Jackson, they changed course. The EPA issues an endangerment finding on climate change. It finds that greenhouse gases are pollutants that threaten both public health and public welfare due to the impacts of climate change. The endangerment finding provides the legal basis for all regulations under the Clean Air Act concerning the emission of greenhouse gases, water vapor, carbon dioxide, nitrous oxide, methane, ozone.
Yay.
Yay! Now it's time to boo. Because in 2025, we had an election in 2025. Trump has called climate change a hoax, and he says he loves fossil fuels because of the cheap energy they produce, and this outweighs any harm. And red states like Texas, Oklahoma are rich in fossil fuels. I mean, let's face it, it's political. He opposes any regulations to address climate change. On January 20th, the first day he's in office, Inauguration Day, one of those executive orders that he signed about 30 of them that day, is called, quote, Unleashing American Energy. And all it does is reflect Project 2025's priority goal of undoing the EPA's regulatory framework.
Ooh.
On July 25, Trump's EPA administrator, Lee Zeldin, formally proposes setting aside the 2009 endangerment finding. Now, after the break, I'm going to get into what the courts have done in the last few years. But I want to digress for a minute. That's why I had this on the first slide, because I want to talk about the second existential threat to our lives: nuclear waste.
Mm-hmm.
It's a long-term environmental problem. We've been using nuclear-powered energy plants since 1958, and more of them are in the works because it's clean. It's one of the ways of addressing fossil fuel. The uranium rods that fuel them wear out on a regular basis. That's a problem. We don't have a permanent program of covering what to do with the highly radioactive spent rods that are dangerous to all forms of human life. And here's where it gets scary. It's estimated that there are some 90,000 metric tons of radioactive waste currently stored at operating or closed reactors that are located in 35 states. That's about 2,224 pounds per metric ton, meaning that we got about 200 million pounds of the stuff sitting around.
Mm.
When removed from a reactor, they're too hot to handle. The spent rods are cooled in water, and once they're cooled, they're put in casts that are then encased in concrete. Now, in 1982, Congress ordered the federal government to build a permanent storage facility for this stuff. And they ordered it deep underground to last long enough for years. And in 1986, the Department of Energy picked a site deep below Yucca Mountain in central Nevada. But the Department of Energy screwed up. It and the Nuclear Regulatory Commission, which is the subdivision of the Department of Energy, it's called the NRC, but by the way, my notes have all these acronyms, and I'm trying not to use them in class because I hate it when people talk acronyms. I have a cheat sheet here of all the acronyms, but so I keep saying the DOE and the NRC, but the Department of Energy and the Nuclear Regulatory Commission did not get the Nevada population on board, nor did they get Senator Harry Reid on board. And Harry Reid was pretty on board, pretty important. Nevada's residents objected, and they stalled construction. And funding was cut during the Obama administration. Who was the Senate Majority Leader when Obama was president?
Oh, Mitch McConnell.
No, he was Mitch McConnell. That came in And 2 years after, the first two, Harry Reid.
Yeah.
That's why funding was cut. For younger Harry Reid said, not in my state, you're gonna put this shit. Pardon me.
It's an acronym.
Now, this problem is not going away. There is one government disposal site, but it's kind of small and it's limited by law to nuclear waste from atomic weapons. So, and it's nowhere near large enough to deal with the waste from nuclear power plants. Until the government gets its act together, utility companies and other local entities have to do the best they can to make temporary storage arrangements. And any temporary storage arrangement requires a permit from the Nuclear Regulatory Commission. And the Supreme Court actually had to deal with this issue this term. They dealt with last May. The case is called the Nuclear Regulatory Commission versus Texas. The commission issued a permit to build a temporary storage facility on privately owned land in West Texas. This would be the first storage site not on the grounds of an existing open or closed reactor or on the government-owned land. Local cattle ranchers in the state objected. They claimed that the statute did not allow the commission to allow nuclear waste to be stored unless it was on the grounds of an existing reactor, whether it was open or closed, or on the government's land. That was their interpretation. And it went to the Supreme Court. The court ruled 6-3 upholding the decision to issue the permit. But which justices were in the 6 is really interesting because it illustrates that strange cases make strange bedfellows. Justice Kavanaugh wrote the majority opinion. He was joined by Roberts, Barrett, and Sotomayor, Kagan, and Jackson. That was the majority that allowed it. The Gorsuch dissented, joined by Thomas and Alito. The majority okayed the plan. They held that the applicant and the NRC had dotted all the I's and crossed all the T's, done what they were supposed to. And they rejected the claim that the applicable that the statute limits permits to places that already have nuclear reactor or are government land. Now, I think what this case shows is that the Supreme Court is prepared to let the Nuclear Regulatory Commission explore any reasonable means to deal with this problem until they can come up with a permanent solution. It's pragmatism. Here's some people who they're going to make some money, but they pick an area where there's not a lot of people, and they want to store some of the stuff here temporarily until there's a permanent solution to this problem. Because Congress has still got to come up with a solution. That law wasn't canceled just because Nevada didn't want to put all the stuff underneath Yucca Mountain. Now, it's interesting. I read in a recent article in a magazine called Science News, which normally is not high on my reading list. And it noted that the NRC, the Nuclear Regulatory Commission, is looking for an alternative permanent site. And that both the NRC, the Commission, and the Department of Energy are planning to try and emulate what Finland and Sweden have done. Now, what those two countries did is they engaged the public in the process of finding a site. They went to the public and said, public, we have this problem. We've got to find a permanent place within our borders to put this stuff. Where should we put it? And they got the public involved in the process, which didn't happen when they picked the Yucca Mountain site. So that's where things stand right now. Personally, I wouldn't count on them getting their act together all that soon. But I think this is a problem. This is why I digressed. Even though the class is supposed to be about climate change in the Supreme Court, if climate change is one existential problem we have, nuclear waste is the other one. And so I wanted to, and the court had a case on it, which I wanted to discuss. Hey, I've been going for almost 40 minutes, let's take a break. But first, how about questions? Constantine.
One of the things that I think an error was made in the whole process of climate change, the idea of climate change, that we have to do something about it, is that it started with forests And it started with taking care of fish. And they're all connected, and they should have been connected at the beginning, so that you have, I think, so that you could have a running start to say, hey, this is a big problem.
That's Constantine, you read that for the Zoomers, Constantine's point was, why didn't they address climate change at the beginning of the environmental movement?
Well,
Okay,
the things that they were doing.
yeah. But the point was that they didn't have the science at that time. If you look at the science and you turn the clock back to 1968, 1966, 1968, they didn't have the science to the point where there was a worldwide consensus that greenhouse gases were a problem.
And the question I have is, they didn't connect the two. That CO2 was connected to forests, was connected to animals, was connected to the whole thing.
But you're assuming that they knew enough to make that connection. And what I'm saying is they might not.
They might. Well, anyway.
Okay. Yes.
When these nuclear reactors were built at El Diablo, etc., how many years were they built to last?
The question is, how long were nuclear reactors built to last? I'm not an expert in this field. My understanding is they figured 25, 30 years.
Yes.
That's not a lot of time.
No.
When you're thinking about the future, it is. When you're thinking about the past, it isn't. And they built these because they wanted the energy. They wanted clean energy, and this was the way to do it. And they figured, we'll figure out the storage later. It's kind of like the ballad of Werner von Braun. Once a rocket goes up, who cares where it comes down? That's not my department. Werner von Braun. It's the same idea. Ron.
El Diablo, you're right, it's about 25 years, and they just decided to ignore the expiration date.
Right.
Continue.
And they're continuing to use it. Yeah.
So wasn't Reed's issue, it wasn't so much burying it in Nevada, it was getting it there. Wasn't that they were so concerned about a train accident or some cataclysmic event that was getting there? Because for Reed, I mean, it was his legacy, because he was, out the door.
That's the question. The comment was that the problem with Yucca Mountain was as much the transportation getting the stuff there as putting it there. And I think that's very accurate, and I should have mentioned that. Yes.
As you were talking, I've been thinking about the mandate of the Supreme Court, which, as we know, is limited to the geographic boundaries of a country. That presents a uniquely challenging situation, I think, for something that is so global in context. And so my question is, what is your thinking about how an enlightened Supreme Court, looking forward to a world of interconnectivity, how an enlightened Supreme Court might address these issues?
Okay, the question is, what do I think about climate change and the problem that the Supreme Court acts locally, but we need to think globally. And what I would say is this: there are two things I want to respond to your comment. First, you mentioned an enlightened Supreme Court. Historic. Most of us, our age group, came of age in the 50s and 60s and 70s as young adults.
Mhm.
And we grew up in, how old was I? 1958, 54. I was 12 years old when the Brown case came down. And from 1954 until the, say, mid-1980s, we had this very progressive Supreme Court. And when I gave the class on originalism last week, I went through a number of all the decisions of the Warren Court. That was a historical anomaly. For 150 years before that, and since then, the court has been essentially a very conservative body. So when you think about the Supreme Court as being a liberal court, you're talking about a Supreme Court that was really unusual, that had only lasted about 40, 30 years, and it had never existed before. But again, what do I think an enlightened court would do to think locally when you're dealing globally? This country produces more greenhouse gases than any other. We are, no, I think now we're second or third, but we're still up there.
Yeah.
And so anything we do has two effects. One is because we're up there, it's going to have an effect on the global situation. Secondly, because we're the United States, we like to think that a lot of people will follow us. And because we may be second or third in greenhouse gases, we're probably first in consumption. And consumption is what the American consumer is what draws the products that are produced by third world countries that are emitting huge amounts of greenhouse gases. So I think that the Supreme Court acting will have I think, yes, it would have a worldwide effect, but their purview is local. Other questions? Yes.
Ukraine has a lot of nuclear power. What do they do with their waste?
Good question. I have no idea.
Yeah.
What does Ukraine do with their nuclear waste?
On the site.
Constantine says they keep it on the site.
Dump it out the back door.
Do they bury it?
Exactly.
Chernobyl is encased in concrete. Chernobyl is basically one big nuclear waste site. They've encased the entire thing in concrete. And it's just sitting there. That's all they can do with it. And that's the way it's gonna be. They can't put it underground. Maybe in 300 million years it will be underground. What was that movie, The Time Machine? Yes, one more.
Yeah. I just had one. I saw that sort of sense. But Trump feels that we're in a war with China, and it's a cyber war. And I just recently saw the graph of how many of these huge AI things are going up, and they're going to suck incredible power. And it's part of the reason that he's reopening fossil fuels, which you call that. If you put all of those together, it makes some sense.
The comment was that the power needs to fund the AI, to put enough power in the AI, the data processing plants that are humongous, that are making the modern language models, the modular language, mass language models, whatever they're called.
Yes.
It's a huge amount of power, and that's why Trump is opening up fossil fuels. I'm not sure about that. I don't know if there's a direct connection here. I think it's more political to solidify his base in places like West Virginia, Oklahoma, Texas, and everything, and the MAGA, and to basically take away the power and influence of the quote elites, which his base hates. So that's it. Let's take, it's 1:15. Why don't we take 10 minutes and we'll be back here at 25 minutes after the hour to the second half. To reduce the power and scope of big government. That's just a starting point to help understand where the court is coming from and some of the decisions I'm going to be talking about. One of their targets was a rule, was a rule that's called the Chevron deference rule. Chevron deference rule, also known as the Chevron doctrine, or it's called the deference rule or the deference doctrine. It's a case-developed rule that applies when a court has to decide if an agency has the authority under the law to issue a challenged regulation. That's the question that this doctrine addresses. In such cases, the deference doctrine requires the court to defer to the agency's decision that it has the authority to make the challenge regulation, as long as, one, the agency's actions are reasonable, and two, that the statutes defining the agency's authority are vague or ambiguous. In other words, if the statute says the agency, you can do this, then they can do it. If the statute says you can't do it, then you can't do it. But what if the statute doesn't say anything about it? Or it says something about it in very wishy-washy language that could go either way. The deference rule was created in 1984. This is not an old rule. In a case called Chevron USA Inc. versus National Resources Defense Council. The opinion creating the doctrine was unanimous. Stevens was joined by Chief Justice Berger and Justices Brennan, White, Blackmun, and Pauth. Rehnquist and Marshall, who kind of were on far opposite sides, were both ill at the time. And O'Connor recused because she had represented Chevron in litigation before she went on the court. The idea behind the rule is if guidance from Congress is lacking because the statute is vague or ambiguous on whatever they're talking about, unelected federal judges should respect the legitimate, reasonable policy choices of those who are politically responsive, namely agencies that would answer to a president who has a constituency. He's answerable to the public. Under the Constitution, resolving competing views of what is in or is not in the public interest when Congress doesn't provide guidance, should be left to the political branches. That was the idea behind the rule. And until 1974, the Chevron case and the deference rule was the most cited precedent in cases involving administrative law. It was cited over 17,000 times in lower courts and over 70 times by the Supreme Court, and it was followed 3/4 of the time it showed up. But conservatives hate the rule. Resolving statutory ambiguities are what judges are supposed to do. The doctrine gives too much power to federal agencies, which conservatives don't like in the first place. In 2015, the Supreme Court weakened the rule. In a case called King versus Burwell, it held that the rule didn't apply where the regulatory action at issue was of, quote, deep economic or political significance. In other words, if this is a really important subject with deep economic and political significance, you don't have to follow the rule. The judges should act independently on the law. The vote was 6-3. Roberts wrote the opinion, and he was joined by Kennedy and Ginsburg, Breyer, Sotomayor, and Kagan. Why? Scalia, with Thomas and Alito, dissented. They claimed the statute in question wasn't ambiguous, and they wanted to overrule the Chevron doctrine. So in the negotiations between the judges had the three liberals had the choice: let them overrule the document in dissent, or join the majority and try and save something in the rule, which is what they did, and that's why the liberals joined with Kennedy and with Kennedy. Personally, I think they were chased with a Hobson choice of either, they'd either overrule the rule right then and there, or make the best deal we can. The conservative justices were just waiting for a chance to get rid of the rule, and they've got it last year in 2024. The case is called Loper Bright Enterprises versus Raimondo. The case is irrelevant. The name of the case is irrelevant. There was a companion case that I didn't bother writing the name down, but they both involve the same problem. In the 1976, there was this Magnuson-Stevens Fishery Act. The Magnuson-Stevens Fisheries Act. Magnuson was from, I think, Stevens was from Alaska. Magnuson, I think, was Minnesota. I'm seeing a nodding back there. He was a senator from somewhere in the Midwest. It provided that federal monitors would be present on commercial boats fishing in American waters to prevent overfishing. But the act was silent about who's going to pay for it. The National Marine Fisheries Service, which administers the act, which is a subdivision of NOAA, which is a subdivision of the EPA, which is a subdivision of this. Following, it negotiated with one of the leading organizations of commercial fishing companies, and they came up with a compromise proposal. The companies would pay for it, but no more than $700 a day to have the monitors on board the boat. And so that was the regulation that was issued, that a boat owner had to cover that $700 a day to have a federal monitor on board. Now, Loper Bright, the plaintiff in this case, was an independent commercial fishing company, but it was not a member of that association. And its members happened to be very conservative, and they went and got funding from conservative think tanks and what have you, and filed a lawsuit to challenge the regulation, which is the way a lot of this stuff happens. It's test cases. They challenged the regulation, saying that the Marine Fisheries Service did not have authority to impose under the law that is under the Magazine-Stevens Fisheries Act. There was no authority given for this regulation. So they sued. They lost in the district and circuit courts, which followed the Chevron rule, the deference rule. It said this was certainly acting reasonable because they negotiated with one of the leading trade organizations, and they didn't just arbitrarily make this rule. They consulted with and negotiated with the people who would have to pay it, and they reached an agreement. So what's unreasonable about that? And the law is certainly vague because it doesn't say anything about paying for it. So the lower courts followed the Chevron deference rule and ruled for the agency. The Supreme Court granted certiorari on one issue only. Should the Chevron deference rule be overruled? And no surprise, the Supreme Court said yes by a vote of 6-3. In this case, the three liberals were in the dissent. Interpreting statutes were vague or ambiguous. That's what courts do, and that's true. You think about it. Every time there's a lawsuit over a breach of contract, does the contract say I have to do this or not? Courts generally decide those issues. Interpreting statutes is an inherent power of the judiciary. Under the Administrative Procedure Act, which is a law passed by Congress that governs all administrative agency actions, due process with their rules of procedure, it assumes that Congress expected the courts to resolve statutory questions, even if they're of a technical nature. Now, the dissent argued that a lot of these regulations are highly technical. They involve scientific issues, and the agency is best able to deal with those issues. What do judges know? They don't know enough to do it. The majority responded to that argument by saying, look, that's what the adversary system does. You have trials. People present evidence. All the scientific information that is going to be needed is going to be part of the court record. And if it's not, that amicus curiae briefs are going to come in on both sides that are going to deluge us with scientific data for and against whatever is involved. And so the judges are going to have enough information to solve these problems. And Robert's opinion says that the agency's view merited respect. You should respect it, but you don't automatically defer to it. The end result, the majority held that the act did not authorize the National Marine Fisheries Service to create industry-funded monitoring rules. Slide.
Which one?
Next slide number 10. That's it. Environmental groups and liberal commentators were incensed. They saw the case as shifting power away from agencies that were aware of climate change and the threats that it presents, and that are much more receptive to proactively doing something about it than the courts that are inherently conservative. The nation called overturning the deference rule the biggest judicial power grab since 1803. 1803 is when Marbury versus Madison was decided, which established that the Supreme Court had the power of judicial review. And so you see, these are two cartoons that I pulled off the internet. The one on the left shows the climate actions being hammered by the Supreme Court, and the one on the right shows the Supreme Court as killing administrative tyranny. So that's what it. But moderately conservative legal scholars were less apocalyptic than the nation. The rule was designed in part to reduce litigation. That's what the Chevron rule was really designed for. That if everybody knows that we're going to defer to the agencies, people aren't going to file losing lawsuits. And it's actually going to prevent litigation. But it didn't. All it did, it didn't reduce litigation over agency issued regulations. It merely changed the questions that would be asked in the litigation. Because people are always going to run the court whenever they think they can get an advantage of it. That's the American way. We're the most litigious, happy people in the world. But a number of states have refused to follow the doctrine in resolving state law questions. And commentators realize that Congress can always amend a statute and decide whether the authority should lie. We should maybe not encourage Congress to pass vague statutes and say, well, we'll let the agency figure out what to do. That's not good law. That's not good lawmaking. Congress should, if there's a problem, if there's an anticipated issue, and who's going to pay for something is certainly an issue that you ought to anticipate. Congress should deal with that. And until they did, resolving such issues really belonged to the courts. As Chief Justice Roberts noted, there's nothing to prevent a court from respecting an agency's view to the, but they just shouldn't defer to that view as a matter of law. And that's what overturning the rule did, except that it did more than that. It basically said there's open season to challenge any regulation if you can raise a credible argument that the agency didn't have the authority to do it. Because if you did, the mindset of the majority of this court is we're going to file a rule in your favor. So the deference rule is gone. How will the Supreme Court treat a dispute over the scope of the agency's authority? A case decided in the last day of the 2022 term, which it was 3 years ago, West Virginia versus EPA, provided a pretty good indication. I covered this case 3 years ago in a class I did called Matters of Regulation, where I talked about one of these talks on was the Supreme Court going to undo the New Deal, this government by agency issue. And this West Virginia versus EPA provided a pretty good indication. The Obama presidency, based on the 2009 engagement finding that I mentioned earlier, under the Obama administration, the EPA issued regulations that mandated that a fixed percentage of all electricity going in the national grid should be produced by power plants that were emission-free. That was the EPA's answer to the endangerment finding that the Obama administration made in response to that Massachusetts versus EPA that had been decided in 2007. The EPA acknowledged that a large number of fossil fuel burning plants would have to be closed. And this has entailed billions of dollars in major job losses, but climate change was too serious to ignore. And the only way to deal with it is to reduce the emission of fossil fuels. And this is a way of starting. And it was, I think the regulation called for 22%, or maybe only 15%. Of the electricity going on the grid. West Virginia, the state of West Virginia, and a bunch of other plaintiffs sued claiming that the regulation was beyond the EPA's authority. Now, this regulation was issued in 2000. It was issued, but it wasn't implemented. And the reason it wasn't implemented is there was a lot of dispute about it. And the EPA had not formally implemented it, so it hadn't taken effect when Trump was elected the first time in 2016. So because the regulation came out in 2009, it takes 5 or 6 years to go through the process of actually from the time that a regulation is proposed, you have a public comment period, people file lawsuits, there's injunctions issued. The regulation never went into effect. And in 2017, the incoming Trump administration withdrew it. But the Supreme Court still heard the case. And what they did is by 6-3, they ignored the deference rule. This was before it was overturned, and held that the regulation was beyond the EPA's authority because of what they called the major questions doctrine. If you look at this thing, the Constitution, after the preamble, the very first words of the Constitution says, all legislative powers herein granted shall be vested in a Congress of the United States. The very first words of the Constitution says that all legislative power is up to Congress. And therefore, the major questions doctrine says that a major question doctrine that is not addressed by Congress should not be resolved by administrative agencies.
Sounds good.
It's reasonable. But the problem is, of course, what Congress frequently doesn't act. Although the majority didn't spell out what is a major question, Justice Gorsuch, in a concurring opinion, suggested 3 possible tests. One was great political significance. One was affected a significant portion of the U.S. economy, or one that intruded into an area historically left to state law. That these were the idea of what are major questions. They address federalism, they address a lot of people, or a lot of economics, or their great political significance. The lead opinion noted that the 1970 Clean Air Act did not classify greenhouse gases as pollutants because they weren't in themselves harmful to humans to be classified that way back in 1970. The court noted that the 1970 Act that the EPA is relying on spoke to the idea that for regulating emissions of pollutants from the source at original power plants that directly affect human life and health. And that global warming is something that's much less esoteric. If Congress had wanted the EPA to make a regulation that applied to the national power grid as a whole, it should have said so. When you say, it's one thing to tell a power plant, you must not emit more than X amount of a gas. But to say that all electricity nationally must be produced a certain way, that wasn't in the Clean Air Act. Congress never gave an agency that power to do that. That's what this court said. The problem is that courts are not supposed to issue advisory opinions. They're only supposed to issue opinions on cases that resolve something. This regulation had been withdrawn before the court ever heard the case. Why isn't it moot? What the minority, the 3 dissenters subjected to was the court cherry picking, taking a case that didn't exist to decide what should happen in the future, as opposed to deciding a case that's happening now. West Virginia was in no danger of having this regulation affect its economy because the regulation had been withdrawn before the case reached the Supreme Court. But the court wanted to throw out this regulation, wanted to send a message, and they did so. Okay, that's the West Virginia case. During the term ended last June, the Supreme Court decided two cases that further limit the ability to address environmental issues. And these are the two that led me, when I knew that these two cases were going to be decided, it's what led me to plan this class. The first one is City and County of San Francisco versus the EPA. And it concerns whether the Clean Water Act allows the EPA to hold local officials responsible if after releasing wastewater into the Pacific Ocean, ocean waters should show an unacceptable level of pollutants. Now, San Francisco actually brought the case because it was concerned that it would face millions of dollars in fines based on the condition of the waters in the Pacific Ocean, that it said, that we're following the rules you gave us. Why can we be fined or penalized because the Pacific waters are less than you think they should be, or less pure than you think they should be? The case was decided 5-4. Justice Alito wrote the majority opinion and acknowledged that the EPA could impose specific requirements to prevent pollution, but cannot make alleged polluters responsible whenever the water quality in general falls below agency standards. Because you cannot prove that this particular first entity is solely responsible for the water to be that level. Now, the case came about because scum and other stuff was floating into Mission Creek. So it was a problem. Justice Barrett, enjoined by the 3 liberals, dissented. She wrote that the EPA should properly supplement specific requirements on what's being discharged with general standards of overall water quality, noting that in this case, discharges from the city sewer system led to discoloration and scum washed in from the ocean into Mission Creek. That's what the case did. The problem with this case is, by analogy, it means that the EPA cannot limit greenhouse gases based on ambient air quality. Because if you say you can't hold a polluter responsible just because the ocean isn't as pure as you'd like it, you can't hold an individual entity that's emitting gases liable if the ambient overall air quality isn't what you want. That's the analogy that the San Francisco case brought. Although it deals with water in the Pacific Ocean, you can transfer that by analogy to the air, and it doesn't give you necessarily an issue. It limits your authority to deal with global warming. The other case presented this past term involved requirements for environmental impact statements. Everybody knows that developers hate environmental impact statements. They've been used by anti-development advocates, causing developers to lose both time and money. Last May, the Supreme Court announced a decision that limited the scope of what potential impacts an environmental impact statement had to make. It held that the impact statement did not have to address indirect impacts from the project in question. Now, the facts of the case are also there. These cases come up in weird situations. Here's this one. A consortium of 7 counties in Utah wanted to build a rail line to collect a portion of the Utah basin that had no rail service to the national railway grid, because there was oil in this area. And there was no way to transport the crude oil to refineries except by truck. And they didn't like that. It's much safer to transport stuff on a train than on a truck, because trains don't crash as often as trucks do.
And cheaper.
And they're cheaper. They're definitely cheaper. So they're gonna build this 88-mile rail line that's gonna connect an oil-rich area in central Utah to the national grid, which would facilitate transporting crude to the refineries of Texas. Now, the National Environmental Policy Act, the 1970 NEPA, that one, it requires the EPA to do this environmental impact statement on any project which needs federal approval. And to build a rail line, you got to get federal approval. You get it from a sub-agency of the Department of Transportation called the Surface Transportation Board. Now, it's important to note here that the EPA that issues the environmental impact statement is part of the Department of Energy. And the EPA prepared a 3,600-page impact statement that measured the impact of the railroad line to be built. And the Surface Transportation Board issued a permit to build the line. But a company in Colorado and a number of others sued, claiming that the environmental impact statement was inadequate. And they said it was inadequate because it did not assess any potential environmental impact from what would happen if there was more drilling in this area upstream, or would there be any additional impact if there was more refinery downstream, because more oil is going to hit the refineries now than they're getting from other areas of the country. Because this is oil that right now is not being refined, it's going to go to refineries down along the Gulf Coast in Louisiana and Texas. So they said the impact statement wasn't sufficient because it did not evaluate potential upstream or downstream problems. The district court agreed and overturned the permit. The Supreme Court reversed, finding that the permit was properly issued. The vote was 8-0. Justice Gorsuch resigned because he was active in local politics in one of the counties in Colorado that was one of the parties to the case. But the other 8 justices all voted for it. But, and this is but, the 3 liberals only agreed to the judgment, allowing a judgment, but they would not join in the opinion. The majority opinion said that environmental impact statements of a projected surface transportation facility, a railway line, need not assess potential environmental impacts that might ensue from any new oil drilling that might happen, or increased refining that might possibly ensue. Any impact from such activities were too speculative and need not be assessed. The EPA prepared environmental impact statement is purely descriptive. The Surface Transportation Board, which is part of the Department of Transportation, that decides whether to issue the permit, is not required to agree with the environmental impacts. And under applicable statute, it can ignore the impact statement and permit the project for other reasons, provided they act reasonably. So it noted that too often that impact statements are used as, quote, blunt and hazardous tools employed by project opponents that delay projects such that the process seems to border on the Kafkaesque. Well, I think that there's probably some developers in Santa Cruz that would agree with this, especially when they consider how long it took to get the approval to build all that stuff that's going up on Front Street. Now, the 3 dissenters joined in the judgment because under the statutes that define the Surface Transportation Board's authority, the board has no jurisdiction to be bound by the unrelated impact statements caused by a consequence of the line being used by third parties. Under the Surface Transportation Board's authority, they don't have to consider, they're not supposed to consider what might speculatively happen. They're only supposed to consider what's the harmful foreseeable effect. But it wasn't necessary to resolve the case to decide if the impact board, if the environmental statement has to deal with these issues. There wasn't, if it's not necessary to decide the case, why are you holding that you can't, that impact statement doesn't have to do this? There might be situations where it's absolutely relevant and they should be doing it. That was the dissent. Well, they lost. So, basically, as much as the hardline conservatives on the court might want to undo government by agency, there's limits to what they can do. All they can do is interpret the statutes that create these agencies in the first place. They can't cancel the agency. As much as the judges would, their majority, Kavanaugh, Brett, as much as Alito and Thomas and Gorsuch would like to get rid of the EPA entirely, they can't do it. Congress created the EPA. It's there. What they can do is chisel a bit here and cut in the powers there, but they can't do away with what the agencies as much as they'd like to. So I say that it all comes down to politics and who's in charge. So let's go back to the 2009 environmental endangerment finding that global warming due to greenhouse gas emissions is harmful to human health and welfare. Project 2025 attacked the endangerment finding as being unwarranted and said it should be annulled. Trump has repeatedly called global warming and climate change, quote, the biggest hoax ever. This past July, as I mentioned, the government announced that it would begin the process to annul the endangerment finding. And it opened a 60-day public comment period that expired in September. The Department of Energy filed a report entitled, quote, a critical review of impacts of greenhouse gas emissions on the U.S. climate, close quote. It was based on input from a, quote, climate working group that consisted of climate skeptics who was assembled by Trump's appointees at the Department of Energy. It's a group of climate scientists filed a 485-page rebuttal. And in August, the Environmental Defense Group, which is a non-governmental organization that is designed, that collects money from liberals, to file the lawsuit in federal district court in Massachusetts against the EPA, the Department of Energy, the Climate Working Group, and a number of individuals, claiming that the defendants, the EPA, the Department of Energy, and the Climate Working Group had violated a whole number of laws requiring openness and transparency and accountability, laws that the defendants have simply ignored. As a result, the Trump administration has no grounds, they allege, has no grounds to rescind the endangerment finding, which apparently it's planning to do formally this coming December. The complaint asked for an injunction preventing the endangerment finding and other remedies. So that was the case that was just been filed a few months ago. On October 22nd, the court issued an order temporarily staying the proceedings because of the shutdown of the government. Because the clerks, nobody was getting paid. So they basically put the case on hold. I checked the docket yesterday afternoon, and that's the last thing they filed note. So I don't know where this case is going. But I will say, as of now, that's where things stand. You have a case pending against Trump's attempt to undo the endangerment finding. My guess is that an announcement will be made rescinding the engagement finding. If not next month, then sometime after the first of the year. But even though a majority of Americans, even a majority of the president's party believe that climate change is a problem that the government can and should do something about, you can bet that the Supreme Court is going to address this issue. If not this coming year, it'll be the year after. And this is a chart that I found online showing a poll that was just taken last August of likely voters, indicates that 79% of voters think that it's either strongly or somewhat think that this is a problem that should be dealt with. And that's a pretty good argument. But I think Trump's going to ignore this because he's really only interested in this group here. That's his base. And the people that will go along with him. So where are we on climate change? We have a Supreme Court majority that opposes the administrative state, but it favors the unitary executive to exercise control over administrative agencies, so they follow the administration's conservative policies. At least while the president shares the conservative views. I would have a different, I think, I'd be wondering if if they were all that in favor of the unitary executive when Mr. Obama was president. Meanwhile, American policy is guided by our president, who admires authoritarian thugs, despises anyone who disagrees with him about anything, makes and unmakes policy decisions on a purely transactional basis, and has no truck with any constitutional check on his power. Congress is closely divided, but both houses are currently controlled by the president's party. What can we do? Object, march, and vote. That's it, folks. It ain't happening. Questions?
Yeah, on that rail extension in Utah,
Yeah.
did they throw out environmental impact?
No, they didn't throw it out but they, remember that there was a anomaly here in this case.
Yeah.
The agency that issues the permit is not the agency that's either required to or has to listen to the environmental impact. All they have to do is consider the environmental effects along with everything else they consider and act reasonably. But they are not required to follow the impact report.
So in issuing the permit, that was okay.
They issued, the permit was okay because it's a matter of law. It's going to be, they did everything they needed to do to issue the permit. There was no legal basis to deny the permit.
Okay, so it didn't really affect.
But the majority's holding, what they held in the case was that the environmental impact statements don't have to deal with speculative future stuff, either upstream or downstream from the specific project under consideration.
So does that weaken environmental?
It depends on whether or not future courts follow it. The dissenters argue that because the quality, the coverage of the environmental impact statement was not necessary to decide the case, what the majority says doesn't have to be followed. It doesn't have to be followed, but it probably will be. It's the way, it's the way conservative judges work. Yeah.
The San Francisco water quality case, it's totally scary, the possible analogy to
Climate change.
Did they understand that they were in effect bringing a test case that would?
Judges always understand what the test case is. That's not the issue. The issue was, did the majority think about the possible analogies that in the future might be drawn to what we're deciding?
Right, and I was actually wondering whether the city of San Francisco that decided to litigate this.
The city of San Francisco decided to litigate this because they were faced with about $300 million in fines.
So just that narrow. That narrow.
That will make
And the taxpayers of San Francisco would have to come up with the money.
Oh, boy, they'd have to raise the tax to get it.
The market.
So it feels like we made a strong case in the beginning of this lecture about the existential threat of climate change.
Yes.
And it feels like the last time there was such an existential threat to the country was Pearl Harbor.
Different kind of existential threat.
Definitely different. But it was there, like Roosevelt immediately assumed, created the national emergency and immediately began to legislate all kinds of stuff. Did the court, were cases brought by others to undo the urgency of the thing? I'm trying to think of how we can become urgent and deal with this existential threat.
I think that the question is how can we deal with this existential threat? It's a different kind of existential threat, and it's not one that we can say, as a country, we should do this. We can all get behind this and do this, and it's going to be temporary, and we got to beat these guys. And once we beat them, and by the way, they're not white. and once we beat them, we can go back to being normal. This kind of threat involves not only a changing away and possibly a decline in our creature comforts, but it doesn't, there's no place where it says, we're going to get back to normal. This is only temporary. I think that's how I see it.
Yeah.
Thinking off the top of my head. But, I'm no expert on this. And on this the whole area that I've talked about today, I may be an expert on law to some extent, and certainly I think I'm qualified to talk about what the Supreme Court does from what I know, but I'm not an environmental historian. And I said that at the beginning, and I'll say it again and again and again. I had the studying I did in the last 2 weeks to get ready for this was basically like, the one advantage I had is I know that you folks would know less than me.
That if you provide the judge with all the data, they can make a reasonable decision. But how many judges, for instance, are experts in climate or environment or that level of science it takes to understand that? So in the reality, well,
all right, let me ask you, I get the frustration, how can judges ever be in a position to have enough knowledge to decide this stuff? Because it's not what they study, it's not what they do. They have a different job. The only thing I can answer you is this. One of the things that I learned as a lawyer, especially as a bankruptcy lawyer, is that I had to learn how other businesses worked, even though I was never been involved. I did a case where I was the lawyer for a creditors committee of a chain of 5 hospitals that was in Chapter 11. And the owner of the hospitals went to China with $3 million of the hospital's money in his briefcase, left his car at the Orange County Airport, and the unsecured creditors and the secured creditors were left trying to sell the hospitals as going concerns. I had to be involved in that and learn how to sell a hospital, which meant I had to know how the hospital operated, where they got their money, what the process was of getting money from the government, from Medicare and Medi-Cal and all this stuff. That's what lawyers do. You learn this stuff in a hurry. And I have no doubt that a judge can learn enough to make a reasonable decision on climate change. Will he put what he learns ahead of his political ideology? No, but a lot of scientists don't either.
That's right.
Yeah.
Ron.
Knowing that you're not an environmental impact sort of thing. I know that when you said there's 36,000 pages or 3,600 pages of the permit, in archaeology, when you do an impact report, archaeology is part of it. And I can just imagine that a rail line went through some sort of areas that maybe had archaeological stuff in it. But there is laws, the antiquities laws, that would keep you from, you have to consider these.
Yeah, and I'm sure I did not get in deep enough into it. I can't answer any specific questions on the UTL rail line of what the 3,100 pages environmental impact statement, what it covered or what it said about it, or what the railroad had to do to avoid violating the antiquities law or Indian burial sites or whatever, because that wasn't what I was talking about. And there was no reason for me to burden myself with 3,100 pages environmental impact report, especially since I probably couldn't get a copy of it online.
And I'm not saying that you should have.
Okay, any other questions? It's 1:15. This has been a great class. I've enjoyed it.
And hopefully after
Thank you.
All done. Well,